Welcome to the Festival of Dangerous Ideas podcast. The following conversation was part of Fodi Digital, an online series with leading thinkers and experts on today's dangerous realities. Because this audio is taken from a digital video format, quality is of a lower fidelity than we usually present. Marcia Langton is a fearless truth-teller who challenges the dangerous orthodoxies of a society that seems incapable of making peace with the truth of its own past. In this searing session, chaired by Stan Grant, she discusses constitutional recognition, treaty, and the settler rage that has blinded Australia's progress. This is Marcia Langton with Dangerous Fictions.
I acknowledge the Wurundjeri traditional owners of Naarm, where I live and work, and acknowledge their elders, past and present, and a shout out to their emerging leaders. Also, I'd like to acknowledge the traditional owners where you are, and pay my respects to their elders, past and present. Stan, what I want to talk about tonight is a very interesting problem that's puzzled me for a long time. And it's not just the question of racism. People think that racism is just discrimination by one group against another group on the basis of some physical characteristics. And so in Australia, what we see is racism expressed most commonly as a kind of white racism against people of colour, or against people who appear to be Chinese. We've seen a lot of that lately. But what I've discovered in discussing this widely with people is that, in fact, there's something very strange happening in Australia, and that the racism towards Aboriginal people is something more than racism, and also something very different. So many years ago, when I was a much younger scholar, I wrote a fair bit about race, and I continued to. But lately I've come to the conclusion that there is something very special and peculiar about the hatred of Aboriginal people. And of course, it is summed up in many Aboriginal slogans. I think most Aboriginal people sense it, and sense it from a young age. So, you know, Australia has a black history, for instance. And your opening comments reflect this sense that we Aboriginal people have of a very peculiar stance towards us that cannot be captured in the concept of racism. There's something more going on. I'll come back to that later. What I want to do, first of all, is lay out what I thought many years ago was this underpinning racism in Australian civil society. So, for instance, I wrote, concepts of race are fundamental to Australian polity and civic life. It is therefore a matter of basic civility, or now I would say citizenship, that we should understand the historical development of ideas about race in Australia in order to avoid the real threat to civil society which racism has presented in the 20th century. So I wrote this back in the 20th century, and the situation hasn't changed. That statement holds true, but there's more, as I will explain. So I went on. The race power is a key concept of the Constitution, which has several times been the subject of cases before the High Court of Australia. Far-right political organisation on the basis of race has become a feature of current political affairs in this nation in the late 1990s. Yet at the same time, few Australians are aware that there is no reliable evidence that any physical reality conforms to the notion of race which is assumed in our language and our legal doctrines and texts, including our Constitution. So I felt then that it was intrinsically important to consider the concept of race, and I applied this analysis at the time to the political circumstances in which the Parliament of Australia was attempting to legislate away our native title rights. And I went on to explain much about terra nullius, the Mabo case, what had happened in Queensland leading up to the Mabo case, and that very plantation paradigm of colonial relations in Queensland that persists. But I did say Indigenous people expect that other relations are possible, relations which will write Indigenous people fully into the modern history of the state. Aboriginal peoples will now appear as groups which might treat with the state on matters such as regional agreements on development, service delivery, and even limited self-governance. I was such an idealist. And I pointed out that Justice Brennan relied on international standards of justice and human rights in the Mabo No. 2 case, particularly as they relate to racism in the decision. So I think we're very familiar now with the idea that terra nullius, a legal fiction, had effectively rendered Indigenous people invisible on the basis of assumptions about their supposed racial inferiority. And then in Mabo, with the stroke of a judicial pen, Indigenous people reappeared as persons with law and property, or at least possessory rights. And that decision was understood by legal thinkers as a judicial revolution, equivalent to the scientific revolution described by Thomas Kuhn, when reigning paradigms are overthrown by the development of a new principle, such as the impact of the theory of relativity on quantum mechanics. Unfortunately, I have to say that since then, the magnificent vision that was laid out for us by the High Court in Mabo No. 2 has been whittled away by mean-hearted bureaucrats in state governments, and most particularly by mean-hearted politicians. And we saw the result of what industry now is prepared to do with the destruction on the eve of this year's National Reconciliation Week, when the Rio Tinto drill and blast team from the project of Brockman 4 utterly destroyed the Yukon Gorge caves. So I think that incident shows us that the idea of terra nullius and the contempt implicit in that doctrine, that is contempt for Aboriginal people, contempt for Aboriginal culture, to the extent that we're completely disappeared, has reappeared in a native title setting where there is an Indigenous land use agreement registered in the federal court as per the Native Title Act. And this incident, so reminiscent of the destruction of the Buddhist statuary at Mosul, magnificent World Heritage areas by the Islamic State, can occur in our nation, in our country, in the 21st century. So my idealism is now rather worn down, just like the Native Title Act and our rights. I hope that sometime tonight or in the coming days that the Rio Tinto board will reconsider their appalling treatment of the traditional owners of that area and of all Australians. I think they regard us as a resource colony, and that, like themselves, Australians have no regard for our cultural heritage and are prepared to tolerate such willful acts of vandalism and the trail of deceptive statements, quasi-apologies, incredulous, implausible submissions to the Senate inquiry, and now a stasis, complete silence from them. So I think that, yes, racism, classical, formal racism of the kind that the terra nullius concept encompassed, still applies. But as I keep saying, there's more. So at the time that we negotiated the Native Title Act, the Racial Discrimination Act was critically important to the outcome, and it served as the safety net in a very odd way to the few rights that we were able to extract from those negotiations in accord with the common law that the High Court had handed to us. So originally, the Racial Discrimination Act was read as protecting the property rights of Indigenous people, just as it does for all other Australians. Now, just on that, all these years later, that has come to pass. In the Griffiths case before the High Court last year, the High Court handed down a decision that I wish we'd had back then. So we said to the politicians of the day, the Racial Discrimination Act means that you cannot deprive Indigenous people of their property without first expressing a clear intent, and secondly, compensating Indigenous people as per the Constitution in fair market value terms. And, you know, I have to say that most politicians of the day had no idea what we were talking about. And still today, I think that would be the case. But in Griffith, a case in the Northern Territory last year, the High Court found on the evidence in that case, in those particular circumstances, the traditional owners were entitled to compensation for the extinguishment of their native title by the Northern Territory government without consent, to 50 cents in the dollar compensation as per the Constitution. And so I think that bolsters the argument that some of us have been making for years, that the Mabo decision recognised our property rights, native title as property, not merely possessory rights. And I find that a very important little win. It's a very important win. And so there was a long debate after Mabo about coexistence. Could native title coexist with Australian titles? Well, of course, what was missing from the argument was the very obvious point, was that it in fact had coexisted with Australian titles for a very long time. It's just that nobody recognised that it did. And I raised in this paper many years ago the principles of the Australian Constitution relating to fair market value for property acquired by the Crown, and the special measure provisions which permit the Commonwealth to enact legislation for members of a race. Now, this is where it gets tricky. It's this race power in the Constitution that allows the federal parliament to pass laws with respect to the people of any race for whom it is deemed necessary to make special laws. A potential protection, no doubt. But these powers also carry the means of fostering reaction against the effects of the Mabo Revolution. And such reaction has gathered force, I wrote. And we see now that There have been many attacks on the Racial Discrimination Act, and I want to thank all of those Australians who joined us in preventing the Parliament from removing Section 18 and making other changes to the Racial Discrimination Act some years ago. And I fear that we'll all have to gather our strength and fight that battle again. I believe that there are people in the Australian Parliament who will not desist from attacks on the Racial Discrimination Act until they've have their royal flush of IPA policy changes. And of course, at the top of their list is the gutting of the Racial Discrimination Act. So be ready for that. Of course, what the Constitution read prior to the referendum was that the race power allowed the federal parliament to pass laws with respect to the people of any race for whom it is deemed necessary to make special laws, except Aborigines. And so it was the 1967 referendum that removed those two words, except Aborigines. And then after that, somehow, by sleight of hand, the race power came to mean that that power only applied to Aboriginal people. And one of the politicians we lobbied back in 1992, after the High Court decision in Mabo No. 2, actually said to me, but that only applies to Aborigines, because only Aborigines are a race. So, you see, what has happened in Australia historically is that ideas of race have evolved and changed from their highly classical repressive forms in the 18th and 19th century. And remember that they really started to kick off only a century before that with German philosophers. And of course resulted in the 20th century in conflagrations such as the Shoah and other genocides. But here we had racism in Australia evolving and taking its own path. So we expected that the race powers could and would be used only to benefit citizens which might be subject to its use, and would only be used to benefit those citizens. We were wrong. Until the Coomeraunc appeal in the High Court, it was inconceivable to many that the power could be used to their detriment. Now, even though the High Court's decision was inconclusive on this issue, and it was a hung court, nevertheless, the Australian government has taken the position that the race power can be used to the detriment of Australian citizens, and of course, most particularly Indigenous people. And this is one of the reasons why it is so important to the far right to abolish the Racial Discrimination Act and remove the only safety net for the Native Title Act and for many of our rights as a special minority. So what makes us a special minority? Well, in the first place, as Rio Tinto might figure out soon, our ancestors have been here for 65,000 years on present evidence. And there's a group of scientists who are trying to prove that our ancestors have been here for 120,000 years. So it is now beyond refute that Aboriginal people are the oldest continuous living culture in the world. But there's a kicker. Let me show you something that made me stop and think about that argument I posed back in the 90s, which I'm sure many of you are familiar with. Oh, I can't screen share. That's a shame. I wanted to show you some data. Well, let me explain it to you. I'm not sure how many there are today, but there are somewhere between 400 and 500 Aboriginal deaths in custody that can be counted from a survey done by the Guardian newspaper using coronial inquiry reports since 2008. The cases before 2008, except for those considered by the Royal Commission into Aboriginal Deaths in Custody, can't be identified. So if we count the 100 or 99 in the Royal Commission into Aboriginal Deaths in Custody and allow for 200 or 300 for the next 2 decades, we may today find that we have between 600 and 700 or 700 and 800 Aboriginal deaths in custody just in our recent history since the beginning of the appointment of the Royal Commission into Aboriginal Deaths in Custody. And I've looked at the data, and of course you'll know that there's quite a large majority of the cases have died from medical conditions that remained untreated. And that category of people who died in custody and a couple of others means that people are dying unnecessarily in custody because of the failure of custodial officers to get the medical treatment. It's a tragic situation, but I felt the need to say it here. But the other thing that struck me was that if you look at the cases one by one, and also related cases such as the children detained in the Dondale Detention Centre. So I'm sure you know that all of the children in the juvenile justice detention system in the Northern Territory are Aboriginal. And then if you look at photos of those children, especially those historical photos from that period prior to the appointment of the Royal Commission into the Dondale Juvenile Centre, you'll see that many of them are white-skinned, very fair, and yet they are Aboriginal. We know who their families are, and they've come out of that system of torture and abuse that they suffered and have become, some of them have become young activists now and are well regarded now in the Aboriginal community. So I've tried to explain to people from other countries and Australians who do not understand these problems that the Black Lives Matter movement also includes our concern for all those Aboriginal people who are fair-skinned who've died in custody. And it led me to thinking, so what is the racism against fair-skinned Aboriginal people about? What is going on? So it's very clear then that, and I really despise the terminology, and I really don't like the theory and thinking behind this kind of terminology, but it is the available terminology, and it's Aborigines and settlers. It's not simply racism. It's a settler population that cannot come to terms with its Indigenous population, its autochthonous population, its native population, it's the people descended from the pre-existing population, utterly incapable of coming to terms with living alongside people who are descended from humans who arrived here 65,000 years ago, possibly 120,000 years ago, regarded by many archaeologists as the dawn of modern humanity. And so when our old people say, we came from this place and only here, you can see what they mean. It's impossible to imagine the timescale and to make sense of it. And so I think the peculiar hatred that led to the shocking torture of children in the Don Dale Centre, children of many colours, some of them very fair, is that expression of settler rage against the people with whom they will not treat. So I think I might leave it there and let you ask me some questions. There's so much more to say about this topic, but I think now we need to really think about these matters very carefully as several jurisdictions move to negotiate treaties. And as I believe a government in the future will do, allow for a referendum so that Australians can vote to recognise Aboriginal and Torres Strait Islander people in the Constitution. And that will truly change the nature of racism. And I hope that the peculiar racism inflicted on Aboriginal and Torres Strait Islander people will evolve and will change and will disappear, and that we as the descendants of the original occupants will be recognised as people to be contended with, as citizens with a special claim on the nation. Because, just as they found in the Griffiths case, it is unconstitutional to extinguish our property and our rights without consent, and compensation is owed. And if that compensation takes the form of recognition, I, for one, would find that to be a very good outcome for all Australians. Thank you.
Thank you, Marcia. I'm sure you'd all agree that it was a remarkable speech covering so many areas of our lives and our country, from law to history to politics and philosophy. And Marcia, by the way, please send in your questions. We're getting a couple coming through now, and I do want to go to some of these questions as they come through. I just wanted to start, Marcia, with exploring the psychology of what we're talking about here, because you have touched on this. You've talked about terra nullius and hatred, and how that expresses itself beyond just expressions of racism when it comes to Indigenous people. And while terra nullius erased our existence in the minds of white Australians and in the lives of white Australians, I wonder too that it didn't have an effect on Australians themselves. I wonder if you could just consider that part of the equation, the illegitimacy that still sits at the heart of this nation, having failed to properly reconcile and recognise the place of First Nations people, having claimed a country on the basis of a legal fiction, and what that does to a settler population in terms of how they see themselves and how they may internalise that in the expression of the hatred that you've spoken about tonight.
Yes, it's a very good question. I think the answer lies with white people, settler people. So, for instance, Henry Reynolds found a quote in a journal, I think, and he titled a book with that quote, "This Whispering in Our Hearts." And you can see what he's getting at immediately. Having tried to eradicate all of the Aboriginal people on their run, these settlers then were struck by the fact that they'd committed a monstrous crime but could not admit to it. And right at the bottom of their hearts forever is this whispering. And it turns up also this very same phenomenon of denial that can't be denied in, I think the book is called The Secret River, is that right?
That's right, Kate Grenville's book.
Kate Grenville's book. you'll remember at the end of that novel, the protagonists are sitting on the veranda of their house, and they realise that following all their massacres up and down the river, they've entirely eliminated the local Aboriginal population. And I think she captured that the way in which those settlers, her imaginary fictional settlers, but not so imaginary, based in historical fact, as you know, must have tried to come to terms with themselves as murderers, but had to face the rest of their lives pretending that what they had done was somehow legitimate. They cannot legitimise it. They just cannot. And this, of course, is what drove Windschuttle, who wrote The Fabrication of Aboriginal History, which hung on a monstrous argument, a monstrous pro-genocide argument that hung on his flaky evidence of 2 footnotes missing. I'm pleased to see that Lyndall Ryan's returned to the fray and has set up the Frontier Violence Project. It's available online. She and her colleagues are mapping the massacres across Australia from the records, the very same massacres that Windschuttle and Paul Sheehan and many others denied occurred. So they've got across the the Queensland border into the Northern Territory. There are more than 200 massacres, close to 300 that they've documented now, and they list their sources and the death toll in each place. And the evidence is there. And yet, you know, here I am, a member of the senior advisory group, advising the government on a voice, a system of Aboriginal representation to government, not to the parliament, not constitutional. And in the course of writing our reports or considering the drafts, we have had to be reminded by very well-meaning bureaucrats who want us to succeed that we must not have anything in our report that looks in any way like truth-telling. Truth-telling is not permitted. But yes, I do think that the impact on the settler populations is a kind of trauma that hasn't yet been fully considered. It's been considered, as I say, by Henry Reynolds, by Kate Grenville, and it's remarkably similar to the way in which the German population had to come to terms with the enormity of their crimes against humanity during the Second World War. And we see the post-Holocaust literature, such as The Reader, just to mention one, Sophie's Choice, and so on. I think we are finding that there are more and more authors of fiction who are prepared to come to terms with it. And I'm trying to think of the name of an incredibly good writer, Mark something wrote about this. And so too did Kim Scott in Taboo, for which he won the, many of the best awards. Yes, I think we're slowly creeping towards an understanding of that very real problem that you raise. And I think it's, you you've hit the nail on the head, Stan, because that is the problem. And that is why they will not allow us to have constitutional recognition, because if they do that, they admit to the enormity of their crime.
Yeah, Marcia, please, I'll encourage you as well. We're getting a couple of questions coming through now, and I'll go to some of those after this next question. I just wanted to put to you, Marcia, you spoke a lot about Mabo and the impact that had in terms of recognising property rights. But I wonder if a consequence of Mabo too wasn't that it then put the onus onto us once again to prove who we were. And the discussion after Mabo became about who is Aboriginal. And I think there's no coincidence that we then saw a lot of the media discussion around dividing people up and deciding on site who qualified or who did not, who was legitimate and who was not. I want to talk about that. You mentioned the fair-skinned Indigenous people and the treatment of those people who may go unnoticed and unrecorded, particularly in our institutions. But that idea too, Marcia, of what has been called the cunning of recognition, the idea that we'll recognise you in one way with a Mabo decision that can recognise property rights, but then put the onus on Indigenous people to prove exactly that they are legitimate, that they are actually the people they say they are. What impact does this have on Australia more broadly, but also on Indigenous people in terms of having to constantly define ourselves and prove to others, often sceptical or hostile about who we are?
Well, it's very complex, and it's a very important question. So on the one hand, there have been some positive determinations and native title has been recognised, but there have been many tragic cases where native title has not been recognised. And it goes to what is called in the law connection. This concept of being able to prove one's unbroken line of descent back to ancestors who lived before British annexation, and to have sufficient recorded historical evidence of that unbroken line of connection. So clearly what happened after the decision was that the judges and the court officials, the anthropologists, the lawyers and the historians became the servants of another crime. And it's as if we were never able to escape from the nightmare. How is this different from the Nazi genealogical office? So there are connection reports, and they're hundreds of pages thick. And if your people, like mine, were massacred year after year until the group was almost extinct, and that is what happened to the Iman, you can't prove your native title. But actually, the Iman have had several positive determinations. But there are lines of descent in every clan who are written out by the anthropologists and the historians because of deaths, because people were imprisoned, because people were sent away as slaves under the indentured labour system. And so the records are incomplete. The anthropologists have incomplete knowledge. Aboriginal people themselves have incomplete knowledge, and try as you might to reconstruct the past, it's just impossible. And so this has caused enormous division in the Aboriginal community and real heartbreak and trauma. Some of the cases have been shocking. The Yorta Yorta case, the DeRose Hill case, and I could go on.
Yes, and the Yorta Yorta case, of course, with that horrible phrase that your rights are washed away on the tides of history. I don't think there's been a more chilling phrase in our history. Marcia, there are some questions coming through, and I want to get to one here particularly that goes to your own views on this, and we can extend this to then talk about Uluru and where that goes, that Uluru Statement process. But there's a question here, why do you support constitutional recognition over a treaty? I'm not sure that's an accurate reflection of your position, but you can tell us about that. And as an extension of that, what are the prospects of either recognition or a treaty?
Look, I support treaties, and I always have, and I'm on the public record. You can read the literature that I wrote 20, 30 years ago on it. It's all online. I'll read out the website, atns.net.au, which stands for Agreements, Treaties and Negotiated Settlements. And I set up that research project back in 2002, well, earlier than that, actually, in 2001. It was funded by the Australian Research Council for the first time in 2002, and it's still going, although it's not well funded, but we have a partnership with the National Native Title Council to continue to record agreements, treaties and negotiated settlements. Now, newspaper journalists are not inclined to cover detail very well, just to understate the problem. And so at one point in Victorian history, just as we thought we might make an advance with constitutional recognition, the group of Aboriginal people in Victoria who are absolutely opposed to constitutional recognition because they believe that it will finally extinguish Aboriginal sovereignty threw in the treaty bomb. And so I asked, why throw the treaty bomb now? We were never able to convince them. And, you know, the main proponent is now a new senator in the Australian Senate, Lydia Thorpe. We were never able to convince them that actually constitutional recognition, far from extinguishing sovereignty, would make sovereignty stronger. But, you know, the 300-page report of the expert panel report and the other literature relevant to this, although we made it available, was not convincing to them. So I find it a real shame that this myth that I'm opposed to treaties continues to circulate in the community. You see, far from being opposed to it, I'm entirely in favour of it. The situation in Canada has long been that there are treaties, there are historical treaties, and there are modern treaties. And when the Canadians repatriated their constitution, without regard for the Aboriginal people of Canada, the Native Americans, those people who had signed the historical treaties, the chiefs went to the Queen and said, we're opposed to the repatriation of the Canadian Constitution without our consent because you, as the Crown, are a party to these treaties. So that brought the Canadian government around to the view that they should negotiate with the Indigenous people. And a provision was inserted into the new Canadian Constitution, Section 35, which recognises treaties and retrospectively recognises all treaties. So if I were an Aboriginal Canadian from a particular tribe and I negotiate a modern agreement or treaty tomorrow and sign with the province as the Crown or the federal government as the Crown, the day afterwards, the Constitution automatically entrenches that treaty. So it's rather like the Future Act and Past Act arrangement that we put into the Native Title Act as an attempt to protect our native title. So in fact, constitutional recognition would entrench treaties if we get the framing of it right. Treaties without constitutional recognition would be highly vulnerable and fragile to political whim.
Does anyone, we have guests here with us. I invite you as well if you want to ask a question. Microphone is just there, so please avail yourself of that. We have some other questions coming through here that I'll get to. But just to follow up to that, Marcia, your reflections on treaty and constitutional recognition. And there's a fundamental question that I've wrestled with myself. I know that you have, and it sits at the heart of all of these questions in Australia. And that is whether liberal democracy, as we've framed it in Australia, with a skeleton of law that is still essentially built on the idea that this was an uncultivated desert free to be claimed by Britain, that a liberal democracy that enshrines individual rights over group rights, and that's often a particular point of conflict whenever we raise these issues, is in fact capable, is in fact a capacious enough idea of Australia to be able to acknowledge rights of First Peoples in a way that is consistent with liberal democracy. Why is that always seen as a philosophical hinge point? That's something that we cannot get past. Is our liberal democracy capable of that sort of innovation?
Well, yes, I do believe it is. The main problem is, Stan, that there's not just a total misunderstanding of Aboriginal society and Torres Strait Islander society, and really a continuing failure to recognise us as full human beings. The problem is also that most Australians don't read their constitution, they don't read their history, and they don't know much about these very important concepts, just, Westminster tradition, separation of powers, the Fourth Estate. You rarely find Australians now who are sufficiently politically literate to be able to engage in a full discussion of these matters. Whereas when I was young, and you'll remember this, you could have these discussions with people. People were historically literate. Now, Britain does not have a constitution, nor does New Zealand. They have traditions. And in the British tradition, there are ALOD, A-L-O-D, allodial titles. And these are a bit like native title. So because Britain has been subject to conquest several times over, there are layers and layers of history and legal concepts and traditions. And the allodial title is an ancient title that persists in Britain and in Europe, parts of Europe, and they predate feudalism. And it's likely that they predate the Roman Empire, but they continue to exist. And so, white Australians say, why can't we have those rights? Well, they do have those rights. Not only do they have those rights where they came from, and there's nothing to stop them from respecting those traditions in granting another person their traditions, but they also have far more rights in Australia than Aboriginal people do. They say, why would we give Aborigines a special right in the Constitution? The Constitution doesn't give us any special right. It's such a nonsensical view of the problem. The Constitution is theirs, entirely theirs. It's a British document. It was passed by an Act of Westminster. The Constitution doesn't sit as a material document in this country. It's in a cabinet in Westminster, in London. And it speaks only about settlers. It is the settler Bible, the rule book for settlers who live in the country that they colonised. It has not a word to say about us. So, can a liberal democracy accommodate our existence? We need to somehow find a way to communicate to them that our existence does not nullify their existence. that their constitution is entirely theirs and that they have entirely excluded us. This is why, I think, psychologically speaking, those horrible men at the Dondale Centre did what they did to those Aboriginal children. That was captured on the CCTV and broadcast on a Four Corners program. That is why. Deep in the settler imagination is a horror of Aboriginal people born of a, we've used the word guilt, but, for goodness sake, complicity in a monstrous crime is what we should say. But anyway, I'm not being very encouraging of the Liberal Democrats amongst us to accommodate our interests, am I?
There is we have one last question, Marcia, and this has been asked by a couple of people tonight, and it comes down to what people can do personally. It's always struck me that, we live in a country that in many parts of the world is the envy of the world, a multicultural country and one of the richest countries in the world, and yet we have First Nations people still impoverished and imprisoned at the rates that we are. And at what point do Australians actually say that we care enough about that to change it? And this is a question that's been asked several times tonight. What can we all do to get behind this impasse? What can the average person do who may feel as if the big political questions are beyond their reach?
Well, they're ordinary political issues. They're matters that go to the Parliament. They're matters dealt with by ministers, just like fringe benefits tax or robo-debt or any other matter that goes to a Parliament. Commit to constitutional recognition and treaties and we shall see a change. Write to your politician. Join the movement. There are events being held around Australia frequently on these matters. Showing up is a good idea. If you're allowed to, I'm not allowed to. But, I think if Australians could just come to understand that they are in no way diminished by accommodating Aboriginal and Torres Strait Islander rights and our due. In fact, if they were to incorporate us into the nation state and make our incorporation such an honourable matter for them and such an honourable matter for us that it could, to some extent, assuage the past, you'd have a country to be truly proud of, to be proud to raise your children in, and to be able to say of that new nation, I love this country in the same way that Aboriginal people do, and they've given me the right to do it because we have recognised their rights. And, people accuse people like us, you and me, Stan, of hating our country because we criticise it. But what they don't understand is that we love our country so much. Like Baldwin, we preserve the right to criticise what is happening to our country.
I don't think anyone could love it any more than we do. Marcia, thank you so much for being with us tonight. We all owe you a debt. I owe you a personal debt that I could never, ever repay, and you know that. And our country owes you an enormous debt as well for your intellect and your leadership and your courage, and all of that has been on show here tonight. I'm sure I speak for everyone in thanking you for being so generous with your time. I hope that you're holding up with everything you're having to go through in Victoria, and my thoughts are with everyone in Victoria tonight who are continuing to experience the full impact of this lockdown. Marcia, thank you for giving us your time here tonight.
This session was recorded as part of FODI Digital, presented by the Ethics Centre. The Ethics Centre delivers programs and experiences designed to bring ethics to the centre of our life. We offer counselling for individuals, consulting, leadership and development services. As a non-profit charity, we rely heavily on donations to continue our work. which can be made via our website. Thank you.